Statutory law. What is it? Where does it come from? And how does it differ from common law? And I think we can answer questions, where does it come from and how does it differ from common law, with the same answer, and that is these are the laws that are created by legislative bodies. It could be the local city council or town boards, to our state legislators, to Congress, right? The federal government. All of these bodies of elected individuals create the laws that we know as statutory laws. Characteristics of these laws: generally, they're going to deal with problems affecting society or large groups of people. Our criminal laws are statutory laws. Every time, think about back in the 1990s, we did not have internet, or at least it was just coming on the scene. It wasn't as it is now, but we didn't have identity theft to the level that we have it now, or computer fraud or hacking. All of those had to be created. They had because those statutory laws dealt with problems that were affecting society. Environmental laws is another area of laws. Legislators also pass laws when they can anticipate that a problem is coming. It hasn't been a problem yet, but something that is coming or could potentially come. Laws passed by local governments, our city council and our town boards, we actually call those ordinances. Congress and state, we call those statutes. And the key here is that they do not conflict with the Constitution. Now you might be saying, there are some laws that I've heard about that conflict with the Constitution, or you think that they conflict with the Constitution. I'm going to come back to that question in a second, and I'm going to expand on that. But I want to answer the question of, like, where do we find these laws? Generally, they are published annually. Every year, the legislative bodies will publish their most recent laws. Now you can go on the websites and find them. There are a lot. You've got to be careful if you're Googling a statute and where it's coming from. It might be paraphrased. You want to look for the official reporter, which is generally the legislative body if you're using online. Otherwise, they actually publish a book of all of the different statutes and laws. Some examples include, that we're going to use anyway for this class: Uniform Commercial Code. That governs the sale of goods, secured transactions, negotiable instruments. That is a statutory body of law. There's laws governing corporations and partnerships. Bankruptcy laws are federal statutory body of law. Copyright law, trademark law, patent law. All of those are just some examples. And as I said earlier, our criminal laws are all statutory. So back to laws that cannot conflict with constitutions, whether it's the state constitution or the federal constitution. And I'm going to talk more about constitutional law in our next section. But what happens when an elective body passes a law that conflicts with the Constitution? Again, I'm going to use the example of Roe v. Wade, which Roe v. Wade made abortion constitutional. And as you know, as of recently, it was overturned. States were creating laws prior to it being overturned. States were passing laws that were in direct conflict with the constitutional law. So what happens is a group or a person who is harmed by that statute will go to court and ask for the court to review or challenge the statute as unconstitutional. So while states might teeter the line, another area is gun laws, right? We have New York State is very strict on the gun laws. It was challenged in court, and it made its, when we talk about courts, you can see the channels as it goes up. And it was ultimately held to be, New York State gun laws ultimately held to be constitutional. So that's one challenge. These laws cannot conflict with the Constitution, or they can be overturned with being unconstitutional. The other challenge about these statutes is how they read. Someone might read a statute and it's by the language, it's very ambiguous to the terminology that's used. So somebody who is harmed by that statute might ask a court to review it to determine whether or not it's called, if it's considered constitutional or not, based on its statutory construction, how it is. So here's an example of a case that was overturned out in California. The law said it is illegal to distribute a violent video game to minors. Now you might be thinking, well, that sounds all right. You can kind of interpret that a little bit. Well, minors, maybe somebody under the age of 18, but is it really? Some of those say 17. Could a minor technically be 16 for purposes of video games? And then the question is, what about violent? Who considers what is violent? And who considers what we mean by distribute? Is that selling, renting, leasing, giving away? Right? So all of these questions were arising from this one statute that says it is illegal to distribute a violent video game to minors. So what a judge has to do to determine whether or not they're going to deem it unconstitutional is review what did the legislators intend. And when legislators are passing laws, there's lots of, opinions and paperwork. It starts usually with somebody proposing a law, one or two legislators proposing a law. And then it gets circulated to the other members, and then they write their thoughts. And then it comes back to the committee. So there's lots of paper trails and ideas about why they're making changes or what kind of words they're going to use and how are they going to define these words. So the courts will go back and look and see what was their intent when they were constructing this statute. And if the courts can figure it out, they'll explain what something means or a term means. But if they can't, they're going to toss the statute out as unconstitutional, and the legislators would have to start all over again. And we're actually having this issue in New York. Again, another, it's not gun control, it's a weapons law about whether certain types of weapons can be deemed unconstitutional. And New York has been hit a couple times. New York legislators have been hit a couple times regarding their description of certain kind of weapons that people can have, including like tasers or a certain kind of knife. And that particular law has been tossed out, I think, 3 times now as being unconstitutional. Legislators go back to the drawing board and start again. So that's how it works with court interpretation and why these laws cannot conflict with the Constitution. So let's talk about the Constitution. And constitutional law is our next type or source of law. And the question is, what is it? Where does it come from? We know it can come from the federal government. That's the one we're mostly familiar with, the U.S. Constitution. But each state has its own constitution. And cities and towns have their version of a constitution, usually called charters, is what they refer to them as. And the Constitution itself provides a plan for the establishment and organization of the government. That's one component of the constitutions. It outlines the duties, responsibilities, and powers of the government, so what the government can and cannot do. And as we know, it guarantees us certain basic rights, right? The 10 that we know, the first 10, the Bill of Rights, has a whole bunch of rights in it, the federal Constitution. And I want to say these protections under the Constitution apply to anyone who is on U.S. soil. It's not just citizens of the United States. It could be somebody who's not a citizen of the United States. It could be someone who's not a citizen of the United States and who's not supposed to be here, who's here illegally. Our Constitution and our basic rights still applies. So it applies to anyone who's on U.S. soil. There have been 27 amendments to the Constitution. It is very hard to change. It's a lot easier for states and Congress to pass statutes to get laws in place rather than to make an amendment to the Constitution. Our Constitution has said that our U.S. Constitution is the supreme law of the land, and any law or any state constitution that conflicts with it, it's going to be unenforceable. But again, it has to be challenged in court. Someone can't just say, hey, that conflicts. As I said, it's hard to change. It is fairly short, 27 amendments. The first 10 we got the following year after the Constitution was created, the 10 Bill of Rights. And while the Constitution itself might be very short, there is extensive case law, we call it case law or constitutional law, that develops from the courts because the courts have to interpret what the Constitution is. These are the federal courts that can only do this relative to the federal U.S. Constitution. It's the state courts that will interpret their own state constitution. And again, Roe v. Wade, I'm going to continue to use that example as we talk about the Constitution because I know you guys know what that is, what that case means. That is a case, we'll call it case law, that the courts use to interpret the Constitution, or whether or not some right was founded in the Constitution. And how the Supreme Court reviews, I think I've mentioned this in an earlier section, some believe that at some point in our history, the Supreme Court was made up of liberal judges, meaning they were a little bit more flexible in their reading of the Constitution. And then the idea is currently that we have conservative judges, where they read the language of the Constitution a bit more conservatively. That's where we get, it's not necessarily a divided line, even though it appears to be pretty political. There's just some judges who believe the Constitution should be read as if it was created today. Society changes, things have changed. The Constitution was written in 1789. The Bill of Rights came in 1791. Back then, our society was a lot different than it is today. So the one view is that we have to interpret the U.S. Constitution as a flexible document changing with the times. And then the conservative idea is, they call them the originators. Nope, we have to interpret it as how the founding fathers wanted it written. So that's where we get this idea that some views, the Supreme Court views liberal, the others are conservative. So that is the discussion on constitutional law and statutory law. Next up, the executive orders and administrative regulations.